Thank you, Senator Morris, and welcome back, Senator Allen.
Thank you, Mr. President. I rise to give my contribution to this very historic and significant debate on the Sexual Harassment and Protection Bill. And Mr. President, I want to make it pellucid that I am very sympathetic to the intent of the legislation, because sexual harassment is a very disgusting act, whether it be against males or females. And so there is the urgency and the need for us as a society to put in place measures to stem or correct this very disgusting act. And Mr. President, as I make my contribution to the bill and prepared myself, as experienced legislators, invariably we go to the memorandum of objects to find out what is the reason and what are the intents of the legislation. And I did just the same for this piece of legislation. And it says, Mr. President, at present, sexual harassment is not specifically recognizing in any existing legislation in Jamaica. However, there is consensus that legislation is necessary to address concerns about sexual harassment, which is employment-related, occurring in institutions or arising in relation to the provision of accommodation. And as I read the memorandum of objects, I then look back at the interpretation clause to look at some critical concepts that are there to clear in my head what the bill is about and what it seeks to do. And in this instance, in the interpretation section, accommodation includes residential and business accommodation. Further, Mr. President, I looked at the definition for institution. Institution includes, and I am going to look at the list of the listing for institutions: a school, college, university, and other place of learning or training. B, a correctional institution or lock up within the meaning of Section 2 of the Corrections Act, Senator Samuda. C, a place of safety within the meaning of Section 2 of the Child Care and Protection Act or any other place for the custody of minors. A nursing home within the meaning of this Section 2 of the Nursing Home Registration Act, or any other place for the custody of the elderly. E, a medical facility and psychiatric facility. F, and this is important, a place for the use of any facility by members of any organization. And G, such other place or facility as the minister by order published in the Gazette designated as an institution for the purpose of this act. Mr. President, as I looked at the plethora of institutions that are listed, I want to highlight two things, because Senator Sophia Fraser-Binns in her presentation indicated that the legislation was for issues relating to the workplace. But, Mr. President, when I look at the list of what is classified as institution, I recognize how broad it is, and that every sector of the society is covered and captured. And I took note of Senator Golding's eagle eyes as she expressed her concerns about the home. But if you look at F, which deals with the facility, and it makes reference to organizations, what I understand, and I would want the minister to clarify for me if my interpretation and understanding is incorrect, is that if an organization rents a facility, that this legislation would have implications there. So if a church, for example, should rent the arena, national arena for crusade, or if it should rent the stadium for a crusade or some facility, then that facility would apply in this instance because it's a facility. And likewise, if it is that a company should have an entertainment activity at a facility, for example, at Mass Camp in New Kingston, so you have Carnival. It's a facility, and an organization is putting on the event at the facility. Then, based on this particular definition, this legislation would apply. Mr. President, G, which looks at and gives the minister the powers to declare any institution under this legislation by order published in the Gazette, is of concern to me, because I wouldn't want to get up tomorrow morning and see a new set of institutions being published in the Gazette without parliamentary approval. And I believe that this is a matter that needs to be addressed, because any such declaration should be subject to parliamentary affirmation. I looked also, Mr. President, further at the definition, because it's a serious bill. It's not a frivolous piece of legislation. And we want to make sure that the best piece of legislation, Minister, is passed in this Parliament. And we support the intent of the bill. And we have no intention of derailing the legislation. We just want to make sure that there is a very good piece of legislation that is practical and implementable. Sexual advances include any one or more of the following acts: forms of conduct or behavior, namely physical contact of a sexual nature, B, a demand or request for sex, for favors of an sexual nature, C, the making of sexual suggestion, remarks or innuendos, D, the showing of pornography or the display of images or objects of a sexual nature, and E, any other physical, gestural, verbal, non-verbal, or visual conduct of a sexual nature. You know, Mr. President, as I read this piece of legislation, this definition, something came to me in terms of the colorful nature of our males and females when they are engaging in the dating process. And I am seeing some of that color. I'm seeing some of that color and creativity taking out in this, based on this, this definition. And I have my concerns. Remember, I am making it explicitly clear that I don't support sexual harassment of any individual. But one has to make sure that we are realistic in what we are proposing. And I see, again, Mr. President, the definition for sexual harassment, which speaks to the making of any unwelcome sexual advance towards a person by another person, which A, regarded as offensive or humiliating by the person towards whom the sexual advance is made, or B, as the effect of I, interfering with the work performance of the person to whom the sexual advance is made, creating an intimidating, offensive, or a hostile work environment in reference to the term sexually harassed shall be construed accordingly. Mr. President, no one could subscribe to a hostile work environment that makes it very uncomfortable for our workers. And so I really appreciate the intent in order to stem that attitude, stem that conduct, stem that behavior in the workplace. Because people go to work and to gain a living and to produce and contribute to the advancement of the country. They don't go to the workplace to be harassed, sexually harassed. And so I understand and support the definition that has been proffered. Now, Mr. President, as I go into the bill, there are some clauses that I see that I have some additional concerns about. And on pages 11 and 15, I want to express a concern that I have about the proportionality of the penalties that are imposed here. And I want to cite in particular 8.5 and 12.7. A person who knowingly or recklessly discloses information kept in a register in contravention of subsection 3 commits an offense and shall, on summary conviction in a parish court, be liable to a fine not exceeding $500,000 or in default of payment thereof to a term of imprisonment not exceeding 1 month. And 12.7 states, a person who willfully obstructs or willfully obstruct or assault an authorized officer in the exercise of any function of the power under this act, or B, fails to comply with a lawful request made by an authorized officer, commits an offense and shall be liable on summary conviction in a parish court to a fine not exceeding 1 million or to imprisonment for a term not exceeding 12 months. I want to submit, Mr. President, that the fines here are disproportionate, and I want to submit, Mr. President, that the 500,000 or up to 1 month, we can keep that, Mr. President, but where I have the problem is the 1 million or up to a year, 12 months. And I want to suggest that instead of up to a year, we reduce it to up to 6 months. So it would read $1 million or not exceed, a fine not exceed a term not exceeding 6 months. On page 18, Mr. President, section 21A, it says a person shall not become or continue to be a member of the tribunal if the person is suffering from a mental disorder within the meaning of the Mental Health Act, becomes of unsound mind, or becomes permanently unable to perform the functions as a member of the tribunal by reason of ill health. Mr. President, the term suffering from, as it relates to a person with any form of disability, is not an acceptable reference internationally. And I want to suggest that there be an amendment so you delete suffering from, so that should be deleted, and replace it with affected by. Mr. President, in general, this particular clause, if you read it and study it carefully, though, lends itself to discriminatory practices against persons with disabilities, because we have seen where on a number of occasions persons with disabilities have been made medically redundant on the basis of them developing some form of ill health. And so this particular clause has to be looked at very carefully because of the international commitments that we have as a country under the Convention on the Rights of Persons with Disabilities, because it can be construed as a violation of the rights of individuals with disabilities. Mr. President, Senator Golding had said, and I think Senator Fraser Binns and Senator Scott Motley, that there is a need for a massive public education program in light of what the bill regards as sexual harassment, because the existing culture, there is going to be a requirement for a cultural shift based on what we are trying to achieve here. And when I look at some of the things that are regarded in the bill as harassment, there has to be an ongoing, consistent public education program to ensure that individuals understand what it is that we are talking about. When I look at the particular section, it says that the various forms of sexual harassment include physical harassment, unwanted touching, patting, touching, kissing, groping, and hugging which has clear sexual undertones. Then you have verbal harassment, unwelcome comments on appearance, physical attributes, private personal lives, sexually suggestive or explicit jokes, insult and put-downs based on a person's sex. Mr. President, I enjoy telling the ladies how beautiful they look. And I enjoy telling them about how they smell. And I enjoy telling them about their dress. I hope that I won't find myself in any trouble with any of my lady friends as a result of the compliments that I am accustomed to extending to them. Because, you know, based on the definition and the classification here, some of those utterances would fit within those parameters. But I am rest assured that, you know, if it is unwelcomed, that is where I would get into some problems. Mr. President, there is a whole list of what is regarded as sexual harassment, and these are not in keeping with the cultural practices of the society, which to us is very wrong and needs correcting. However, this is where the issue of a consistent public education comes in. Furthermore, the law now has a major deficiency. It lists all the harassment, but does not make a provision for the person being harassed to caution the harassee to stop, because what is being done or said is offensive. If this provision is not included in the law, we are going to have some difficulties. We are going to have a lot of frivolous cases being brought to the tribunal. Such a provision would indicate to the person being harassed that they are, sorry, Mr. President. The person being harassed is offended and would trigger a process of caution to the harassee to discontinue. Then this is where the complaint mechanism would trip in. And Mr. President, here I want to propose an amendment to clause 3A to read. And I'll just give individuals a time to find 3A so that they can follow. 3A, all of the circumstances surrounding the act, conduct, behavior shall be taken into consideration. And this is the amendment. Such considerations shall include an objection in the form of an cease and desist statement to the unwelcome conduct or behavior by the person being harassed. That is the proposed amendment that I am suggesting to deal with the mere fact that an individual needs to state an objection that what is being said or what is being done is in fact offensive.
Repeat the clause. Repeat your...
Okay. All right, let me just find it quickly. Okay, and it reads,
What clause is it?
all of the circumstances surrounding the act, all of the circumstances surrounding the act, conduct,
What clause is it?
3A. Okay, sorry about that.
So it's clause 2, subsection 3A, correct?
Yes.
Page 5.
All of the circumstances surrounding the act, conduct, or behavior shall be taken into consideration. Such considerations shall include an objection in the form of a cease and desist statement to the unwelcomed conduct or behavior by the person being harassed. And I believe that that would solve the mischief that we have been discussing in the debate thus far, Mr. President. Mr. President, you know, as I said, that this legislation is very important and timely. And as I was preparing myself for the debate, I had a discussion with my wife, and I said to her that I am very happy that I met her 12 or so years ago, because when I was dating her, Mr. President, she would never allow me to come near her. And I remember one day, Senator Samuda, I remember one day taking her for lunch. And having completed lunch, and we went outside, I said to her, you know, life is very unfair. Very unfair. Because all the men who see you and they compliment you, they will tell you how, oh, you look beautiful. Because they have their eyes to see. But I am at a distinct disadvantage, Senator Longmore, because I am not able to see. But in a blind man's world, we see things differently. So I said to her that the sighted man says, seeing is believing, but for the blind man, feeling is knowing. And Mr. President, that was how I got my opportunity. That was how I got my opportunity. And Mr. President, different times, different season, things are changing. And so we have to make sure that we understand that it's a new season, new environment that we are venturing in, and it is going to require significant resocialization of both males and females in terms of how we relate with each other. And I also am a bit concerned, Mr. President, about our entertainers, because our entertainers help to drive the culture in terms of how women are treated, how women are viewed, and how we relate with them. And I am suggesting, since this legislation also falls with the minister that has responsibility for the entertainment sector, that special focus will have to be given to the entertainment sector to sensitize them as to the provision of this piece of legislation, because they will be required to play a pivotal role in terms of the cultural shift that is required under this piece of legislation. Mr. President, I support any move to stamp out the sexual harassment or abuse of whether it be male or females in our society. And I look forward to the public education, public awareness campaigns to sensitize the population as to the cultural shifts that will be required under this piece of legislation. May it please you, Mr. President.
Thank you very much, Senator Morris. Senator Morris? No, thank you, Senator Morris. Senator Morris? Thank you, Senator Morris. Go ahead, please.
Thank you, Mr. President. And I hate to be the last one speaking, but I will try my best to make it. Oh, I'm not. Thank you. I'll try my best to make it very brief. Mr. President, I rise this evening to talk about this critical piece of legislation before us, the Sexual Harassment Protection and Prevention Bill. Now, since the bill was first brought by the Portia Simpson Miller administration, considerable work has gone into making this bill what it is today. A legislative win for the Jamaican people, for the men and the women who have endured forms of harassment in workplaces, in various institutions, who have borne the struggle because they feel as if they have no recourse, or they're simply just afraid. This bill provides a glimmer of hope. And I want to commend the minister, as well as others who sat on the committee, and the technical team, as well as contributors, for putting together this critical bill. And while it's not perfect, we understand, it is indeed a step in the right direction. The direction of making gender equitable laws that will protect all Jamaican people. Now, there are a few things that I want to, or that I admire and appreciate about this bill. The first thing is that the bill is gender neutral. We understood and affirmed that sexual harassment can exist or happen to persons of all genders, and it's important that they have mechanisms to protect them. Notwithstanding this, I also want the public to acknowledge that the majority of victims or persons affected by sexual harassment are women. 1 in 4 Jamaican women have reported being sexually harassed during their lifetime. However, we also know that there's an issue with underreporting of males, sexual harassment in males. And I want to use this opportunity to really encourage employers to be more deliberate with the coming bill about removing the stigma associated with men reporting sexual harassment. This can be used as an opportunity to encourage them to speak out and to seek recourse in case of events of sexual harassment. The second thing that I appreciate about the bill is that it speaks to a wide array of vulnerable populations. And I believe that the committee did well in ensuring that the most vulnerable groups are protected under this legislation. Now, when we talk about vulnerable, I speak to youth, I speak to the elderly, I speak to persons with mental health disorders. And as a young woman, I'm pleased that this bill offers that kind of protection, especially to youth. It offers me hope that not only does the bill seek to address harassment in the workplace, but it also speaks to institutions such as universities, correctional facilities, and places of safety which are intended to serve our young people. We would have seen the headlines of university students' claims being snubbed because they've brought the university into disrepute. What this bill does is to create a space where young people who often feel, in cases of harassment, disbelieved or shamed or snubbed, is that the bill protects them and places the responsibility of preventing and protecting against sexual harassment on the employer or the institution in this case. And so it gives them some amount of support to report and also seek recourse. So I believe that that is a win for young people. The bill also speaks to forms of harassment such as quid pro quo, where employers or employees rather are promised benefits in return for sexual favors. In the Jamaican context, we all know the stories. We've heard them, where employees, especially younger employees, and even more common, young women, are cornered by their employers and sometimes even blackmailed into providing sexual favors. Now, this bill, I believe, is so powerful because it protects these vulnerable individuals and offers them recourse if they find themselves in these situations. I also want to speak about harassment of individuals in places of accommodation. I can't forget the story of a young woman who was told by her landlord that if she don't do so and so, she have to leave. And that is such a common situation for many youth, for many women, especially in Jamaica. And so I'm happy that the bill takes time out to address these instances that are so very real and that are happening today. So I'm excited to see the bill being able to protect these persons. There's one matter that I want to raise, and I know that colleagues have raised it before, but I hope that we will consider the extension of the review period. I think that if we are able to extend the review period, it will allow for a more fulsome observation of the bill in action. I also want to put before the House that it is important during this time while the bill is being operationalized that we collect data. Data is important. And I noted that the minister has some plans to roll out research on sexual harassment. I welcome this, and I hope that we'll move with urgency so that we can have that kind of empirical data that can guide a more fulsome and robust review of the bill. In closing, Mr. President, I also want to add my voice to the need for rigid and robust behavior change campaigns that will address some long-standing cultural misconceptions that encourage sexual harassment. And when I talk about these campaigns, I'm not just talking about plastering some posters all over the place or plastering billboards, but what this will require is looking at the cultural elements that already exist and specifically targeting those elements with theoretically designed campaigns that will really get into the psyche of Jamaican people and prompt some behavior change. because we know that human behavior is complex. It won't happen in 1 year, it won't happen in 18 months, but we have to start this process of sensitization to make the bill effective. I want to end by saying that employers also have a duty to put an end to culture that perpetuates harassment in the workplace, particularly in male-dominated industries, by taking appropriate action to eliminate toxic behaviors and attitudes. It starts there, by rebalancing corporate power dynamics, by teaching employees and showing how they can promote an environment free from sexual harassment. As I take my seat, Mr. President, I want to encourage the public to take the time to actually read the bill. Take the time to ask questions about things that you don't understand, and take the time to become more familiar with concepts surrounding sexual harassment so that we can all, as Jamaicans, be more aware and play our part in tackling the social problem that affects us all. May it please you, Mr. President.
Thank you, Senator Morris. Senator Brown.
More amendment? Not coming back. Mr. President, I see more amendment being circulated at this late stage. I had prepared my remarks prior to some of these amendments, and I'm going to therefore speak to my remarks, and to the extent I can incorporate the amendments, I will. If not, I'm going to be raising them in committee stage. Even if I did not address them here. I want to start by saying that, like my colleagues, we support the principle of no sexual harassment in the workplace. We support providing facilities and policies against sexual harassment in the workplace. I recall, sir, a lady by the name of Singing Sandra, a Trinidadian Calypsonian, who for decades have championed the fight against sexual harassment in the workplace. I recall her singing, "You want to help to mind your family, you want to help your man financially, but nowadays it's really very hard to get a job as a girl in Trinidad. You're looking now to find something to do. You meet a boss man who promised to help you. Hear that, Alvin? And when the man lay down the conditions, nothing else but humiliation. They want to see your whole anatomy. They want to see what your doctor never see. They want you to do what your husband never do. Still you ain't know if the scamp will hire you. Well, if it's all this humiliation to get a job these days as a woman, brother, you can keep your money, I keep my honey, and die with my dignity. And it continues. I don't think, Senator Samuda, women should die to keep their dignity. It's time for them to live with their dignity. And Singing Sandra for decades have championed this position. But it hasn't been easy. Contrast that, President, with a quotation from the eminent jurist Uriah Parnell in 1984, struggling with what is gross misconduct in a matter that went from the IDT to the Supreme Court. This is what Justice Parnell said then. If the foreman in the factory should merely pinch the alluring hip of the newly appointed female technician while on the job, that would not necessarily be grounds for instant dismissal. He should be warned if the lady did reject his advance. But if during lunch break and against her will, she was forcefully held in the restroom or the canteen and dragged or lifted to a corner with the intention to ravish her, the worker or workers responsible would have been guilty of gross misconduct. I believe the society has come a far way from Parnell dicta. It has come to the point, Senator Campbell, Leslie, that you can't wink. In Parnell time, a pinch on an alluring hip might have been allowed. And I hope there are no more judges who hold Parnell view today, because I see we are sending the matter for appeal to the Supreme Court. And woe be it that any judge in the court feel as backward as Parnell's view was in '84. And I start there because this struggle has been a long struggle. It's a struggle which, as Prime Minister, and has been stated before, the Most Honorable Portia Lucretia Simpson Miller saw it and brought a bill to the Parliament. And credit in bringing that bill must go to the current leader of the opposition, Mark Golding, who pulled this team from the Ministry of Justice and speedily drafted the bill. And I'm aware, because then Information Minister Sandra Faulkner was delegated by the Prime Minister Portia Simpson Miller to work with Mark Golding in developing the bill, which was tabled in this Parliament. So credit must be given to Portia Simpson Miller, Mark Golding, Sandra Faulkner for bringing us this far. Now the baton has been taken on by that side. And as you run with it, we ask that you do so like the Jamaican female relay team. Take it to the winning post. And I raise this, taking it to the winning post, because we have seen where a number of bills have been passed by the other place, passed here in the Senate, bills assented to by the Governor General, but bills which has made them law act, but have not been implemented. Senator Fraser spoke to the Road Traffic Act, and I'll come back to that. But I remind this Senate that the Disability Act of 2014, Senator Morris, is still not implemented. So that is what, 7 years since we passed it, not 18 months. So you're rushing to review in 18 months? We're saying a bill passed 7 years ago, assented to by the Governor General, still not implemented. For hundreds of thousands of people protection, people living with disability. So this sexual harassment bill could walk that way if you don't run like the Jamaica female relay team. If you run like Shakari instead of Fastlane, we're not going to get far. Senator Gill, you will recall the ease with which we passed the Road Traffic Act. My colleague, Senator Skeffrey, plea for a little delay. I plea for delay. Senator KD Knight plea for delay. We on this side were pleading for a little delay so we could fine-tune it. Minister in charge of government business said, it had to be done now. We had to stop the carnage on the road, the indiscipline, and that the regulations to implement the Road Traffic Act would come within 3 to 4 months. When was that bill passed? December 2018. 3 years almost. The regulations haven't come yet. Lucian Jones, Dr. Lucian Jones is telling us we're surpassing the fatality target for this year. Where is that bill? Where is the act? Where are the regulations to implement the tough measures in the Road Traffic Act? So, when it comes to this bill, that I support in general, but I have some amendments I wish to propose. Why should I be sanguine that is going to be implemented quickly and that your 18-month review will take place? Clause 42 says the minister may make regulations. I wonder when those regulations will come. Sooner than the Disabilities Act? Sooner than the Road Traffic Act? So it's nice to pass a bill. The thing to do is to implement the bill. Give it legs. Let it work. Let it protect the people. Otherwise, all we'll be doing is clapping the desk in celebration. But the real protection for the people wouldn't be there. And against this background, President, you'll be aware of a law called the Protective Disclosure Act, passed in 2011, properly called the Whistleblower Act, which encouraged people to talk about corruption, to report abuses. That law has not had a single case in 10 years used. Well, you can tell me the case. But this law, and if you want to tell me there's 1 or 2 in 10 years, go ahead. Make your day. But that law rushed through the parliament. I could see, as Senator Gill is aware, that I represented the trade unions before the Joint Select Committee. And I told them that that law requires so much of the whistleblower that it wouldn't work. And I see in United Kingdom where we took it from, people are losing their job for whistleblowing. And so the Jamaican people are wise. They didn't run follow this and whistleblow. So we could end up with this Sexual Harassment Act becoming like the Protective Disclosure Act. Nice on paper. Very good on paper. But ineffective. And so I want to spend some time, having said that, to go through some of the difficulties I find with it. The bill requires that it may come into force on different days. That's fine with me. But would like to get a sense from the government is what aspect will come in first? Will all the aspects come in before the 18 months? So if you are sure of your policy, tell us so we could measure it. Because I don't just cheer because people say, well, 18 months. The 18 months is going to be impractical. Let me say it here now. No matter how much you applaud it, it is going to be impractical for a review. The review will be meaningless. And because what it signals is that you don't have confidence in this legislation. That is why you need to review it so quickly, because you don't have confidence in it. Let me take you through some issues. In the definition on page 2, it speaks to contractors. It said contractors perform for compensation or reward. But under the definition of worker, there is no requirement for compensation or reward. You just work for. So somebody come into your yard and chop down a tree, they're a worker, even if they're not being paid. And I believe the definition of worker should include being compensated. Because otherwise, a man cutting down your tree in your yard, just passing and doing that, winks at your helper, and you are responsible for that person as a worker. And I hope that we'll look at these issues. Second thing in the definition I want to raise, because it runs through, is institutions. And just as Senator Golding points out the difficulty of the school, I don't know, because I was on the Joint Select Committee, even dealing with universities, consideration was given to what is called the jurisdiction of the visitor. So when you say you must exhaust all the channels, that means exhausting all the channels, including the visitor. We have had some negative experience in the past. Certainly in the University of West, in this case, there's a new visitor. In UTEC, the Governor General by law is the visitor. But if you don't go through the process, including up to the visitor, you can't go to the committee, you can't go to the tribunal. You can't go to the tribunal. And so that could extend the period. And I'd urge a response as to whether the visitor was taken into account. At the definition under institution, at G, it says the minister may, by order published in the Gazette, designate as an institution for the purpose of this act any other place. But that doesn't come, Senator Morris, Floyd, with affirmative resolution. So the minister can declare any other place, such place, as an institution. There ought to be some protection, some parliamentary oversight, and I'd recommend that as an amendment. I note, for example, it speaks to respondent in the thing. Respondents really only come up in clause 36. And as it comes up in 36, you get the sense that the respondent is only an employer. 36, 1B, 3, and 4. But one would think that the respondent would come up also under discussion of complaints to the tribunal. Because there's a clause which says you can't reveal information before the tribunal. I think that's 28. Before the tribunal starts a hearing. But if an allegation is made against Senator Gill, he ought to be told by the tribunal, not after the hearing starts, but before the hearing starts. And so because he's then the respondent, and I'm not sure that 28 Senator Golden captures that sufficiently, and I'd urge that that be examined. Others have spoken about issues of the gestures, etc. In my view, on page 4, it is too subjective. The fact that the absence of intent, and I can see where the absence of intent doesn't nullify it. But if sexual harassment means the unwelcome act, advance, it is left, President, to the view of the victim. I thought of a case of my colleague, Senator Floyd Morris, caught winking. And somebody said, that wink was at me, he was making a sexual gesture because I was once a Miss Jamaica. She's not here. I wasn't calling her name. So it becomes so subjective. And the call, and he has made a suggestion, that we ought to be able to say before, guess what? I don't like what you have done. But if both of them are at the University of the West Indies working, that wing could become now an allegation against him as a co-worker. Just because somebody, he might not even was winking in her direction. So he thought. But a wink did take place. So we have to do better than that. We have to be fair. We have to be balanced. And I would suggest that we examine that. I was discussing this, Senator Gill, with a female, through your president, with a female attorney who practices labor relations. And the person said to me, Lambert, this is too emotional, this bill. And I said, no, you can't say that. Because I can't go to the Senate and say that. But would you be willing to dress up like me and come to the Senate and say that? Because if I say too emotional, the owls are going to come at me. But she's a female attorney with a lot of experience, decades of experience. I am not going there with you, you may know. But the reality is, there is a degree of subjectiveness that we need to work around. I don't know if the Attorney General Chamber is present, but the definition of worker, page 4 to page 5, speaks of an apprentice, a trainee, or an intern. And I want to be provocative, President. I want to ask, does that include a probationer? And I'll tell you why I raise it. Because the Ministry of Labor said a probationer is not a worker. They put that in writing. And now the Attorney General has that to deal with. So I ask the question, if in the definition of a worker here, because the word probationer is not there, is a probationer not a worker? My view is a probationer is a worker. But I've seen government adopt different position on that. I want to address 3 and 4, clause 3 and 4. I have no problem with the duty to have a sexual harass-free workplace. But when you come to 4, Mr. President, it says every employer. Every employer. So, Senator Campbell, the plumber you employ for 1 day to come fix the pipes makes you an employer. And Senator Golden is correct. Every household who employs a gardener or a domestic worker is an employer, even if you employ them for 1 day of the week. And that employer is required to have a schedule, first schedule, policy, which is 4 fine print page that you must discuss that with the employee. You must put it up in a conspicuous place. And what if the employee can't read? You have to do an audio version of this. This is going too fast. I'd suggest that we could start, and the amendment I've seen doesn't meet it, to say that the minister may exempt an employer. Maybe we should start with saying 10 and more employees. We start off immediately with you. And then another year or sometime after, we then apply it to less than 10. Because what you're saying here now is every household who employs somebody must in 12 months put up this policy, or else clause 12 would authorize officers come at them. So the 92-year-old pensioner who employs somebody to look after his house better put it up. And if he doesn't comply, he could end up not with a $200,000 fine, but anything up to $1 million. That not look right. That not look fair. And so I have a difficulty with this every employer. I think we can come to it in a graduated, as
Speaker's time has expired.
yes, you mean I only have 15 minutes?
Mr. President, the Speaker's time has expired. May be given sufficient time to complete his presentation.
Question is that the Speaker's time having expired, he be given sufficient time to complete his presentation. All in favor? All in favor?
Aye.
The ayes have it. Continue, Senator.
Thank you, thank you. So, President, you drive North Coast, but let's say Senator Campbell heading South Coast, runs into the bars in Poorhouse and that zone. Ladies tend to be dressed in a certain way in those bars, shorts and I drive past, man. As a client inside that bar, you have to be very careful now. But you are required under clause 5. You're required under clause 5 to have a report made within 2 days. And what if action isn't done in 2 days? What happens if no action is taken in 2 days? And why are we requiring that the report must only be in writing? What if the person who is making the report is illiterate? That person is excluded? Why can't we put a clause which says preferably in writing, but not limiting it only to writing? Otherwise, we may just exclude some people from this. I noticed that the bill really only in one place addresses the question of a worker at the KSAC or KSMC harassing the mayor. As an employer mayor, this law doesn't say you can take any action. It just says it 9-7, that it must happen. There should be some protection for employers who may be harassed. And I have had to deal with a case recently, President, of an employer a male employer being harassed by a female employer. Salacious text messages. But this law doesn't protect the employers or lay out a scheme in which employer can act. I don't find it, except for at 9-7, it's saying that may be so. I dealt with the issue of the visitor, and I dealt with the issue of worker shall not harass an employer. But what if it happens? Where does the law take us? I want to come quickly to the, well, the colleagues have spoken to the role of the authorized officer. I want to ask a practical question. How many staff members are there at the Bureau for Gender Affairs? We're going to make them field officers. Senator Gill, I believe we have more labor officers now than the entire staff of the Bureau of Gender Affairs. And the labor officers have told us in another committee that they're not enough to deal with the large establishments in the country, much less to deal with every household that employs an helper, part-time or full-time. So I think we're setting up people here because we're saying and giving these authorized officers enormous power. But the truth is, we won't have enough of them. Or is it that we intend to expand the public sector? It doesn't strike me that this is consistent with a 9% of GDP, wage to GDP, for the public sector. So it's some inconsistency, some incoherence, and I don't think that this is working. Why should it be, President, that we can warn people, but we put that at 8, at 12-8, after we take action against them? I think first we should warn people. These authorized officers should warn people. Give them the 30 days before you contemplate taking any action that could lead them to be fined up to $1 million or be imprisoned. And then I come to the question of clause 13. Sexual Harassment Tribunal. I have no problem with the establishment of a tribunal. And for someone who has spent a lot of my time operating and appearing before a tribunal, I have a sense of how these work. The Industrial Dispute Tribunal is probably the most active. Teacher Services Tribunal, also very active in terms of number of cases coming before them. But none of them is as large as 14 members. And what this bill is saying, you shall have 14 members at 13-1. You shall. It's not even saying, let's start and grow up where 14 become a maximum. How many cases are going to be coming before this tribunal? Maybe like the Protective Disclosure Act, maybe 2 in 10 years. So why are we going to put 14 there? Instead of scale it up. So I think that's something to be considered. And I could probably just jump from there to 25. 25 deals with compensation. It's not clear whether the tribunal is going to be compensated per hearing. They're going to be compensated as employees like the Industrial Dispute Tribunal. It's not clear. And if we're proceeding with a bill like this, at least give us some clarity. Because if you're going to be paying them per hearing, then you might find it difficult to get people as busy as Senator Campbell when he was in private practice. Having been appointed to the commission, to the tribunal, he's busy doing other work. And when you come to set dates, you find difficulty, delays. So the government needs to make up its mind. Are you going to be employing them permanently and having them there? But I don't think you need 14, and I think you need to make up your mind as to it. But 25 tells me that there's uncertainty currently. Then the composition. You're setting up with deputy chairs, but you're requiring the chairman to chair every one of the sessions. Do like the IDT. Allow deputy chairs to chair. So you could have 2 or 3 panels running simultaneously if you need that, and if you have so many cases. I believe there's a conflict between 14.2 and 16.2. Need to be sorted out, need to be clarified. And at 16.3, I'm not sure if the amendment came about gender balance. What you're really talking about is having diversity. Because you can have a gender balance of 3, in 3. There's no 1.5 male and 1.5 female. They're going to be 2 to 1. 2 male, 1 female, 2 female, 1 male. What you're talking about is diversity. And I'd urge that 16.3 be addressed. That. At 18, a tenure of 3 years doesn't give people a chance to settle down. Tenure too short. It allows ministerial control. Give people a longer time so their independence can shine in the way we saw from Senator Golden today in terms of her independence shining through. Also, it will be interesting to note what is the government take and the minister making the appointments in light of constitutional challenge now to the constitutionality of the IDT because the minister makes the appointment. As the Attorney General Department settle off on that and determine whether or not it is a constitutional position, because a challenge is now in the Supreme Court to that. Let's look at it and agree. 26. records of the proceedings to be kept. What format? Do we have enough stenowriters to be adding a new tribunal? I hope there's not enough work there, which will require you to build a pool of stenowriters that doesn't seem to exist. Arguments about the 6-year point have been raised. I won't go there. I've mentioned the question the 28 needed to be addressed, corresponding to the respondent. 29, why does the tribunal need to have its own investigators if the parties are to bring and make the case before them? Will it be that the investigator report is adopted over the evidence heard at the hearings? And by the way, if the hearings that are going to be paid for are those under Part 6, what happens when the committee meets or the panel, the tribunal meets to work out its procedures? Will they be paid for that? Because those won't be hearings under the definition of hearings in this bill. At 32, if I might jump to, there's a 31-2. Tribunal shall not conduct a hearing or shall discontinue a hearing if the tribunal receives notice that the complainant does not wish the hearing to be continued. Almost everything else said in writing. I would hope that this notice is also in writing. But it doesn't say it, and I'd urge that that be included. At 32, it says the tribunal may take evidence on oath or affirmation. But it says also, if you refuse to take the oath or affirm, you may end up in court for contempt of the tribunal. But it doesn't require you here at 32 that you shall take the oath. Seems a conflict to me that needs to be dealt with. And it can be dealt with by saying the tribunal shall take evidence on oath or affirmation for the purpose of the hearing, rather than making it discretionary. The decision of the tribunal, will it be by majority or does it have to be unanimous? Of course, the majority is what I would prefer, but I don't think that it is set in the law. Whereas I would hope that we don't leave that to the tribunal setting its own procedure. Let's state it in the law. A decision may be by majority, as is the case in the Labor Relations and Industrial Dispute Bill. I have a difficulty, President, with 36(1)(c). Make such other awards as may be appropriate in relation to the complaint. This sounds like a carte blanche that the judges have. But this is an enormous power, and it needs to be restricted, in my view. And then we introduce at 36(2) awards for feelings, which is new. I don't think the common law recognizes this. The Industrial Dispute Tribunal can't make an award for feelings. But we're now introducing this here, and it does not appear to be any limit. So it's new, feelings, emotional distress, I'd love to get some more what is intended here. Chairman, at 38, it calls for appeal. That's on page 26. Many tribunals, including the Industrial Dispute Tribunal, an appeal is by way of judicial review, but not an appeal. A challenge is by way of judicial review. Judicial review is different from an appeal. In an appeal, the judge, hearing the appeal, look at everything. Look at facts. Look at procedure. In judicial review, the facts are the domain of the tribunal. And the judge may look at it and say, I would not have come to that conclusion, but there was evidence before the tribunal, and they acted. When we make this appeal instead of judicial review, as is in the Industrial Dispute Tribunal situation, and I urge that we adopt the language of the Industrial Dispute Tribunal on this. What we're doing, Senator Williams, we're undermining the complainant. Because the complainant is protected in judicial review by the discretion of the court. Much more. Once you go by appeal, the complainant is going to find it hard to continue the case. It reminds me of a man from the West, President. I think it was Kipling. Kipling, he was RM in Hanover. He wrote a little book about the court being the people's theater. I remember in it, he had a chapter in which he said, a lawyer had lost before him and said, yes, I get to know, appeal, knowing that the other person could not manage the appeal. And because of a deep pocket, the complainant, having one down there, lose. And I fear that the complainants are going to be disadvantaged by adopting 38, which goes on appeal rather than via judicial review. I recommend the approach of judicial review. People have spoken to 41. You know, there's a charge, there's a crime of murder. Doesn't stop people from killing people. To tell me that a fake, a false report is going to attract a fine or imprisonment, not going to stop people from making a false report. Not going to stop them. And I tell you, there are many cases that I've seen where somebody comes up to be terminated and they pull the question of sexual harassment. I had a case of a lady in a public sector company, and she was under pressure from the managing director. And as preparing her case, I said to her, you ever considered that you could accuse him of sexual harassment? And she said, but that's exactly what it is. She hadn't told me that is a case of sexual harassment that was leading to the pressure that she was under. But it's easy. I was in a conference in Trinidad, and somebody told me about this kind supervisor in an Eastern Caribbean country who had loaned some money to a lady to assist with some difficulty she had. He wrote a check. Difficulty came in the workplace. She had to be terminated. And she accused him of sexual harassment. Not only that, that he paid her off. And she was able to produce the check. That is evidence sufficient to cause him to lose his job. So, 41 is not going to change that. It will happen. And so, because we're going to have committee, I will stop at that. But suffice it to say, the 18-month review is too short a period. Not because we don't think the act should be reviewed, but by the time you get to the 12 months, 6 months leave to the 18, you're not going to make it. And I don't want you to take Portia's bill and turn it into a protective disclosure act of no value, of no use. So, with those, President, I will take my seat, and I thank you for listening to me. I thank my colleagues for extending the time. But again, I give praise to Singing Sandra. They want you to do things that your husband never do. Time to stop it in the workplace and beyond. May it please you.
All right, thank you, Senator Brown.
Mr. President, perhaps we can suspend for 60 seconds just to allow colleagues to rejoin the chamber. Mr. President, it almost being 4:30, I ask for, well, the act.
Mr. Samuda, you're asking that we sit beyond 4:30?
Yes, President.
And you don't have to say it's almost, it's 4:30, somewhere, you know. So the question is that we sit beyond 4:30 to complete the business of the day. Those in favor? Against?
Thank you, Mr. President. Mr. President.
Thank you, Leader. Thank you, Senator Brown. Thank you, Leader.
All right, let me take it, because although I have quite a few things.
Senator Longmore.
Yes. But better safe than sorry. Okay. Thank you, Mr. President. And allow me to start by thanking all contributors to this very important debate before us today. I think we are all agreed. We're all agreed that this bill represents a significant milestone in our very long history to provide protection to victims of sexual harassment. And certainly today, due respect and regard has been placed at the feet of the Most Honourable Portia Simpson Miller, as well as the Honourable Babsy Grange, who have both played an important role in the development of the law that is before us, in leading the process, which has been so critical. We've certainly all celebrated the fact that the bill is gender neutral, and I think the majority of us have recognized that, notwithstanding that it is gender neutral, the reality is that sexual harassment is primarily experienced by women, and therefore this bill is likely to serve the role of providing greater protection to them. But it provides protection across the board, Mr. President, and this is a truly positive day for Jamaica and our development of an equitable society, a balanced society where we don't normalize the stress, the depression, the anxiety, the impact, the negative impact that sexual harassment has had and does continue to have on victims thereof. We've noted statistics. I think Senator Morris and I had used the Jamaican Women's Health Survey statistic, which found 1 in 4. I think Senator Scott Motley had used a US study, which had 1 in 3. But clearly, our 1 in 4 was reporting, who reported, not that had experience, but who reported having experienced. And the underreporting that's recognized in respect of men has to be recognized in respect of women as well. It is not an easy thing. It has been far more normalized for the chuckle change subject, Senator Allen spoke about the cheeky experience. Everybody has learned how to get out of that straying hand and to step lightly without disrupting whatever social engagement you are in. We have all learned these small coping skills that maintain social equanimity around us. Don't disrupt whatever function or event or meeting that you're at. And you press it down and you move on because we have had to. And this is the spectrum of coping management, from it is that you need the job or you need the place to live, to you really cannot afford to disrupt the meeting at the time, and then it's too embarrassing to go back and pick it up. It is from the minor to the major. There's a broad spectrum of extent to which it occurs, the context within which it occurs. But we're all agreed that it is something that must be addressed. But when I speak about the underreporting and the coping mechanisms that many have had to learn, I raise it in the context as well of the suggestion that we put the onus on the victim to do something to signal to, I believe a suggestion was made for an act of cease and desisting to be placed in an amendment that must be considered, as opposed to the general consideration. And it's not an amendment I support because it perpetuates what is a consistent cycle that the onus must always be on the victim. So women mustn't go to clubs, women mustn't wear tight clothes. Not men don't rape. Women must change their behavior. So women mustn't wear attractive clothing to work. Women mustn't laugh too loudly. Women must say, I don't like it, even if it's uncomfortable and makes it, and is in a difficult situation for her to so do. But not the victim must think about his actions and whether they are welcome. Not the perpetrator must think about his actions and what he does. And as I've said before, this act, this bill, does not intend to remove flirtation, to remove the starting of relationships, etc. It just really requires people to respect the concept that someone may not want your advance. To think, just to think, which is a human capacity, and therefore just a matter of respect, which is something that we all embrace as part of our culture as well. Respect is big for us. So why can respect not simply be thought about in this context as well? Respect my right to not want you to make an advance to me. And respect my right to work in a way where I don't have to be thinking about that. Why, when I'm doing my work, should I have to be thinking about how I manage your desires? You need to sort yourself out. So, Mr. President, that is an amendment that I don't think will be suggested. Rather will be taken on board. The broad language of the bill does require that a tribunal must consider, or the complaint procedure must consider all the circumstances, which means that they must weigh them. And certainly if the person has expressed offense or whatever, then it will be weighed. But the fact that they have not should not prejudice their ability, because the circumstances may not have been such where the victim was able so to do. And the whole point of this thing is that it has had to be suppressed for so many years that to now put the onus back, to my mind, Mr. President, would be a retrograde step and a disservice to all the efforts that have been put into this bill. Mr. President, it is, again, we're all agreed that a cultural shift is needed, and public education, sensitization within organizations, as has rightly been pointed out by Senator Gale, as well as broadly, which has been embraced by every one of us who have spoken. We do need broad thinking about this, because it is about behavioral change, and it will take time. But this bill is undoubtedly a critical step in giving the impetus to that change. Mr. President, another issue that has been raised in the context of the debate by more than one speaker is the issue of timeline for review. And it is unusually short, and that is recognized, but I think the number of speakers who have also acknowledged that the bill is imperfect in its current state, and it is so new, because it certainly can't be described as a rushed bill, because this has passed through across 3 administrations. It has crossed through 2 prime ministers, 3 administrations, I believe 3 ministers' hands, although one was a minister without portfolio. And a joint select committee that really dedicated a lot of time and thought, but because the area is so new and touches so many different aspects of unquestioned aspects of our lives and institutional lives, it is just recognized that a shorter time period that will allow us to address perhaps even some matters that have been raised here today, and Senator Golding Campbell has already said, thrown down the mantle with Minister Grange to say that she'll be holding her to the review of the particular issue in relation to the disciplinary procedure or internal procedures, which she had raised earlier. But there are some things that were raised today that have been we've been able to find solutions for, legislative solutions for. So while one wouldn't have anticipated having more amendments for us to consider today, at the very least, they're quite clear and fit in with the discourse that we've engaged in today. So they do contribute to making a better bill, and they will be as a result of the debates that have been held here today. So I think the collaborative effort that has been underway in the Joint Select Committee has indeed made its way into this chamber, and therefore we will have a much better result, and that is something for which I certainly give thanks. I wanted to note in particular the starting just to look at some of the amendments before we go into the committee, but not to go through all, because of course they will be taken at that point in time. But given that we're adding adding two, and replacing two amendments, I think it would be appropriate in the closing of this debate to just note them. So in clause 4, we'll be addressing the concern that has been expressed in respect of addressing micro employers and circumstances which perhaps might not necessarily be considered here right now, but their ability to ensure that there is a policy framework statement that's put up, etc. One is unlikely to put up a policy framework statement in one's home or in one's, corner shop. But it is something that's important to think about. What the solution that we have found, however, is to give the minister the power to acknowledge where that there may be employment circumstances which are not appropriate to require this policy framework document. And while we anticipate that domestic arrangements will fall within that, I won't name that as the amendment. So the amendment will be in clause 4 to add a subclause 7, which says that the minister may, by order, subject to affirmative resolution, so it will come back here to make sure that we have oversight, exempt an employer from the provisions of subsection 1. And subsection 1 is the provision which requires, that's 4.1 is the one that requires the policy statement. So that will allow us to not, to give the appropriate thought, policy consideration of how the exemption, to whom the exemption should apply without affecting the substratum of the bill. Clauses 5 and 6, the adjustments are really to make sure that the language covers the ability to notify electronically. And so whether by text or whether by email or otherwise, so that clauses 5 and 6 speak to electronic means or otherwise. Before, electronically didn't align with the Interpretation Act and the Electronic Communication Act of Jamaica. So we've just adjusted that language there, fairly simple. Electronic Transactions Act, sorry. In clause 8, we're also going to be making an amendment, but by renumbering D and E as E and F, and then inserting in D the finding of a sexual harassment claim. This is about the register. What should be placed in the register, which is what is required for every employer, institution, in respect of the complaints that are filed, sorry, not complaints, sexual harassment claims that are filed, to ensure that that is also not, that's not an option for what's placed in the register. It can't only say that someone has been accused and what action has been taken. It must say what the finding was, which could be an exoneration as well as a finding of harassment. So that's in there, as well as the broad provision for other prescriptions. And this should assist with ensuring, in the circumstances raised by Senator Golden Campbell, that in an institution, whether educational or otherwise, there is exoneration if rather the exoneration is noted if it exists. Certainly, when we speak about the context of understanding that teenagers are at that period of learning how to interact with each other, and therefore it's something that has to be thought about, we also have to recognize that they're also deserving of protection, and no less so than adults. So before you reach into the criminal realm, this matter of sexual harassment in educational institutions, we're aware that it exists. And this provides a mechanism for those institutions that actually don't have the depth to have a procedure or the impetus to undertake. So again, this is all about finding the balance. It's a new area, and we do feel that, that where we are now, while imperfect, provides a good balance for protection, and that we will look more closely, as Minister Grange has committed to, on how it is that we also protect internally. The change that is also being made in respect of filing false claims is also, we think, a matter which will address some of the concerns that have been raised here today. So Clause 41, as it was pointed out, relates to complaints.
Sorry, Leader, just trying to understand. In relation to 4,
yes,
there is an amendment on the first list of amendments, and then there's an amendment.
Yes,
are we
there's a
abandoning,
second amendment to 4, but
are we abandoning the one on the main sheet, on this sheet?
What's that?
You're abandoning this amendment here?
Not abandoning it,
so
but,
both,
but it had been circulated already, so I'm just going
adding
through the
this.
new ones.
Okay.
Yes. In committee, if anyone has any concerns about, because undoubtedly they'll be raised. Right, thank you. Just the new ones, as they hadn't gone around before. The Clause 41 of the bill provides for the false complaints and makes false complaints an offense. But complaints are defined as complaints made before the tribunal. So what about sexual harassment claims, which are defined as those which are made within the institution or within the organization, but are also deserving of protection? So the fix for that issue is to amend 41(1) by deleting it and simply replacing it with the words, a person who knowingly makes a false sexual harassment claim or a false complaint commits an offense. Both are defined terms, so it simplifies the matter and makes it quite clear that a false complaint or a false claim is wrong either way, and both are offenses. And of course, these offenses are not offenses that need to be taken to the tribunal. They're parish court offenses as provided for in the Act, and therefore would be subject to the normal course of law. The upper limit of the fine is $1 million, of course, as has been otherwise established. And I just want to remind that the fines that are provided in here are upper limits. They are not the fine. I know sometimes the headlines sometimes grab the upper limit, and then the discussion becomes about whether the fine itself is appropriate. But there is discretion in the court to determine any amount leading up to that fine or up to the maximum number of months that's provided. And the judge will consider what's appropriate in the circumstances. Mr. President, I do think, I know I said I would only deal with the new amendments, but I think it is important to just make clear, as I had mentioned them in my opening, and they are particularly significant, the matter of separating the appointment of authorized officers from the role of the tribunal was one that was done on a deep review of the issue of separation of powers, and the Fair Trading Commission case, that was the landmark case, and subsequent decisions that have made it clear that the judicial and investigative powers should not lie in the same institution. And there was a finding that the case law would make vulnerable to challenge the provision, as it were, because the tribunal was actually appointing the persons who were to investigate, and would also, the tribunal would be carrying out the judicial process, the quasi-judicial process. So they've been separated, and the appointment for the purposes of investigation now sits under 12.5, and that was part of the amendments that was circulated. That is the powers that's assigned to that person, and the way in which they can carry out their role. That's now provided under 12 as set out in the list. And I also wanted to just make clear in respect of 36, I will make the jump to 36. This is the provision again, this is about separation of powers. This is about the tribunal itself. Here, what had occurred when the bill was first promulgated under the leadership of PM Simpson Miller, that scheme had rested on a court being the final arbiter of these matters. And when the policy changed to provide a tribunal, as there was broad stakeholder feedback that this would it would prevent people from bringing actions. It would make it less likely. It would be it would dampen the enthusiasm of persons to bring their cases, to put it one way. Backlogs, you would have all the problems that exist in the court system. So the decision was to take the time to establish a tribunal, and that is what has been done. But the jurisdiction of that tribunal to make all of the awards that a court could do, that had not been changed. So all of the remedies that had been the remit of the court had been transposed into the remit of a tribunal, but this couldn't actually be the case, and therefore on a review that was adjusted as set out now in the list that has been circulated, that had been circulated by email and again tabled today. So we will, I'm sure that has been noted, but we will go through. One of the amendments on the list itself that have been changed, there are two in particular that have been changed, but as I'm in 36, you will note that the fourth amendment in 36 is noted as the deletion of subclause 3, and that is a provision that that is a clause that provides for any award to be claimed as a civil debt. So that is not being deleted. What's being deleted is that what's being changed is that it would now be, it would have a limit. So it will now read that subclause 4 will be deleted and substituted, therefore, for where the tribunal makes an award by way of a direction for the payment of compensation to the complainant, the sum so payable may be recovered by the complainant summarily in the court as a civil debt. So this is just making sure that the award can be enforced and that persons on the face of the bill will be able to, on the face of the act, will be able to understand that they can make a claim based on the award of the tribunal if it has not been honored at the first instance. The other amendment, two amendments on this list, is clause 28, which is now taking the standard form duty of confidentiality, which is we've found in other legislation, so this language will not surprise anyone and would not require me to go through. So, Mr. President, I won't go any further in terms of extolling the virtue of the bill, the virtues of the bill, and will ask that we take second reading of the bill as we move to committee, where we can look again probably more closely at the amendments if there are questions which arise, and I am hopeful that they won't. But thank you very much, Mr. President, for your indulgence.
Thank you, Minister. The question is that a bill entitled the Sexual Harassment, Protection and Prevention Act 2021 be now read a second time. Those in favor? Against? Madam Clerk?
A bill entitled An Act to Make Provision for the Prevention of Sexual Harassment and for Connected Matters read a second time.
Thank you, Madam Clerk. The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. Thank you, Marshall. Thank you very much. So the bill is before you, and I put clause 1. Those in favor? Against? Ayes have it. I put clause 2. Those in favor? Against? Ayes have it. I put clause 3. Those in favor? Against? The ayes have it. Madam Minister, I believe there are 2 amendments to clause 4. The first amendment is contained on the larger sheet. The second amendment is contained on the second sheet, which was served today. I put both amendments. I beg your pardon? On the major list, let me refer to it as the major list. I put that amendment. That's this larger sheet. Those in favor? Against?
Sorry, are you going to the second sheet?
Then I'm going to go to the second sheet. Amendment contained in the second sheet. Those in favor? Against?
Sorry,
I never heard you. Sorry, Senator Brown.
Just a comment. Second sheet says, the minister may by order subject to affirmative resolution except an employer. We would believe it should address categories of employers so that it does not appear to be a single employer. Because if the concern is about the micro and the householders and so, then it ought to make it clear that it's categories. And I've seen other legislation that attempt to do it in that way rather than a single employer.
I think the issue is a drafting one, so it is to exempt an employer. The intention will be to address categories of employer, but I am awaiting a note that will help clarify that matter. But it,
to move on from it?
I certainly do.
And we come back to it because I really believe strongly that it should.
Yes, I don't have a difficulty.
If you were to put a Y there and say exempt any employer, would that solve the problem?
Our category.
Yes, they're saying that any employer, but it's not category.
Yeah, all right.
No, so if you exempt any employer.
Yes, they're fine with that. Is an appropriate adjustment.
Okay. So I put the amendment on the second sheet, which would read, the minister may by order, subject to affirmative resolution, exempt any employer from the provision of subsection 1. Those in favor? Against? I put clause 4 as amended. Those in favor? Against? Thank you. I put clause...
Before, I made the point about the visitor, the jurisdiction of the visitor, and I raised that in relationship to 4.3H.
Senator Brown, we'd have to recommit that, you know.
If you want to proceed, proceed.
Okay. I put clause 5. Those in favor? Turn on your light, please. Turn on your microphone, please.
There are 2 amendments to clause 5 on the major sheet.
On what we refer to as the major list.
Yes, sir.
So I put the amendments to clause 5, which are contained on the major list. Those in favor?
Aye.
Against? So I put clause 5 as amended. There is an amendment on the major list to clause 6.
Aye.
Concern on clause 5.
Oh.
5.1.
Sorry, 1 minute. I put the amendments but not put the final thing. Oh, I'm
Yes.
sorry.
And I have
So
an amendment to propose.
Right, Senator Brown.
5.1 requires that the claim be in writing. And I had proposed preferably in writing, which allow for an interpretation that it could be made. Otherwise, because if somebody is illiterate and can't write, you preclude them from it. So it's an amendment which allows for other form of reporting rather than limited only to writing.
I think, Mr. President, that the complaint, that someone could write the complaint for the complainant if it were necessary, because these are serious, there are consequences that flow, and one would not want to get into a he said, she said without there being an ability of an employer who also has a duty under this. So it's more than one person's, or even it's not only the matter as between the two people. I think that we would be straying too far in that regard. I think that if someone needs assistance in a report being made, that can be found easily and given, rather than to allow for a verbal complaint to trigger a process which has significant consequences.
I move to 52A. It requires that if the complaint is against a worker, I understand to be a co-worker, the co-worker must be notified within 2 days, shall be notified within 2 days. Why is it the 2 days? And the question is, what happens if the 2 days pass and the shall hasn't been met?
It's an offense for an employer not to take the actions that are required under the Act, including right here at 3, where it's a failure to take the action under 2. So if the worker is to be notified within 2 days and the employer doesn't so do, then they have committed an offense, so that the worker who is being protected has a right of action against the employer.
I know, but the question is why 2 days? Because if somebody goes off on leave and a complaint is made, and you can't come...
I would imagine that would be considered in the circumstances as to whether it would be actionable and whether... Meaning, if it happens on 3, if it happens, meaning, if an action were to be brought, the person who's bringing the action would have to demonstrate that there's reason, there's just cause to bring that action. The fact that it slipped a day or somebody was on leave and it didn't happen, that's, I would say, a reasonable excuse. So, I'm not sure what you are suggesting.
I'm saying you require a mandate that's be done in 2 days. If some circumstances prevent it from being done in 2 days, what is the consequence? You're saying it may be a reasonable excuse, but the law doesn't say that without a reasonable excuse.
Well, what it says is that a worker who's aggrieved by the failure, so there would have to be a consequence of this failure to act.
No, it is saying if the employer doesn't notify within 2 days, then what happened to the complaints?
What it says is that a worker who has been aggrieved...
Relative to the co-worker.
Relative to the co-worker, if the complainant has been aggrieved, then an action can be brought against the employer. But perhaps there's an amendment. But this was discussed by the committee, and I'm actually being reminded that this is why it can also be done electronically, because if the person is on leave, they can be sent an email or a text. But this was considered, and it was felt that 2 days was a reasonable period within which somebody should be notified that there is a claim against them, that should be made.
Okay, thank you. So I now put clause 5 as amended. Those in favor? Against? There is an amendment to clause 6 on the major sheet, deleting the word, to delete the word electronically and substitute the following, whether by electronic means or otherwise. Those in favor of the amendment? Against? The ayes have it. I put clause 6 as amended. Those in favor? I put clause 7. Those in favor? Against? I put clause 8. Those in favor? Yes, there is an amendment
We have an
to 8.
amendment to 8
Yes, on the minor sheet.
Can we call it the short sheet? Rather than minor. Okay, so clause 8 is to be, yes, sheet 2. Clause 8 is to be amended by renumbering paragraphs D and E as paragraphs E and F, and to insert the following new paragraph as paragraph D, the finding of a sexual harassment claim.
Thank you very much. Members would have heard the amendment which I now put to clause 8. Those in favor? Against? I put clause 8 as amended. Those in favor?
Aye.
Against? Ayes have it. I put clause 9. Those in favor?
Clause 9, sir. Clause 9. And 9-7, 9-2.
1 minute. I put clause 9. You have a comment on 9?
Yes, I have a comment.
Senator
That's
Brown.
At clause 9, 7, it says a worker shall not sexually harass an employer. What is the process that the employer can bring against an employee who sexually harasses that employer? We understand what happens if it goes the other way. What is the process here? It doesn't seem to be any.
I don't understand the question.
I'm saying, if an employer harasses an employee, there's a whole process in the act that follows. But if an employee harasses an employer, what process exists for the employer to act?
No, there is one process, and if it is that a report should be made to the person who is charged with implementing your process, you can go straight to the tribunal. So there's no difference between who it is who has meaning it could be that a worker is harassed by the employer, and the employer is the person to whom you would make the complaint. In that context, you would make a complaint directly to the tribunal. Similarly, if it is that it is the worker who is harassing the employer, so that the employer is who wishes to make the complaint, clearly the complaint would be made directly to the tribunal.
I might understand by what you're saying that if the harassment goes against the employer by the employee, there's a Section 27 complaint that can be made by the employer. And that's a sure I saw it there, but it's your law, your bill, but I'm not so sure that 27 deals with that. But
I'm sorry,
if it
Mr.
does-
Chairman.
Okay. Thank you. So I put clause 9. Those in favor? Against? I put clause 10. Those in favor? Against? I put clause 11. Those in favor? Against? Ayes have it. There is an amendment on sheet 1 to clause 12. I think that's one of the amendments that the minister had gone through.
Yes, Mr. President. This is, there are two amendments, one which deletes and replaces clause 1, and one which deletes and replaces clause 5. 12.1 and 12.5, sorry, subclauses 1 and 5.
Thank you. So I put the amendments on
I just
sheet.
want to make it clear, President, that I'd raised the issue of the need for a warning by these authorized officers before they embark upon court action. We see that 200,000 for people without masks, and to take the householder to court without a warning and giving them a chance to make amends sound to me like a repressive approach, and I want to put on record my opposition to this.
Thank you,
Because I know it's
Senator
going to
Brown.
bite poor people, just like the no mask thing has beaten some of them.
Thank you, Senator Brown. So I put clause 12. Those in favor? Yes, it's the amendment I'm putting, Senator Sinclair. I put the amendment on sheet 1. Senator Sinclair, anytime you think you can do a better job, don't hesitate, you know.
Senator Brown, can I get some protection?
I've been noticed a creeping ambition, you know. I don't know. I put the amendment on sheet 1 to clause 12. Those in favor? Against? Ayes have it. I put clause 12 as amended. Those in favor? Clause 13, which I put. Those in favor? Clause 13. Clause 13. Those in favor?
No, I have a question. I raised the question of the 14 members and whether or not we should not amend it to scale up. So no more than 14 members. Allow you to scale up. But as it is now, you're required to have 14 members at the very beginning.
I think given that the composition with the number who should be attorneys at law, the number who should be mediators, etc., and the others selected from persons, I think it would become a little difficult to apportion. So I think the safer bet, Mr. President, would to proceed as it is, because certainly composing the board, it still has to sit as a panel or as panels, and undoubtedly the management of that aspect of it would be sufficient.
So you want it to remain as it is?
I do, Mr. President.
So I put clause 13. Those in favor?
Aye.
Against? Ayes have it. Clause 14, no amendments there, and I
No, is it the intention at 14 that the chairman should sit at all sitting except for his absence? Because if you have deputy as in 16.2, the language here seems to be, that's at 14.2, seems to be in conflict with 16.2.
I don't see any conflict.
Sorry?
I'm not seeing a conflict.
In the absence or inability of the chairperson to act in any sitting of the tribunal, one of the deputy chairpersons shall act as the chairperson at that sitting. At 16.2 it says the chairman or a deputy appointed may chair a panel. So what it strikes me as is that the chairman will chair all the panels, except, but that's not the intention. The intention is really for 16.2 to be effective. You probably don't need 14.2.
No, 14 is about the general composition of the tribunal, and 16 is about the panels and how the panels shall be composed to sit. They're not incompatible. It's two absolutely different things.
thank you.
And they work in and of themselves.
Thank you. So I put clause 14. Those in favor? Against? Clause 15, there's an amendment to clause 15 on sheet number 1. And I put that amendment. Those in favor? Against? Ayes have it. I put clause 15.
Just to point out, this is a 16. Sorry, you just said 15. Sorry,
Yes.
Mr. President.
So I put clause 15 as amended. Those in favor? There's an amendment on sheet 1 to clause 16.
Yes, Mr. President, and I just wanted to point out that members might recall there was the issue of what gender balanced meant in terms of the panel, and the language that was changed is just to say that both genders shall constitute the membership of the panel. So whether it's 2 men, 1 woman, 2 women, 1 man, it will be fine. Thanks.
So I put the amendment to clause 16. Those in favor? Against? I put clause 16 as amended. The next amendment is on at 28. Can I go to 27? Can I go from 17 to 27? No problem. No problem. I put clause 17. Those in favor? Against? Ayes have it. I put clause 18. Senator Brown?
Yes, I believe it's too restrictive, the tenure not exceeding 3 years. There should be no problem in allowing members to hold office for more than 3 years. By the time the 3 years come on, person begin to learn. Tenure up. So I know they can be reappointed, but I also know that if their decisions are not comfortable, they may not be reappointed. And that is why I believe a longer tenure would give for greater independence of the members and the tribunal.
Mr. Chairman, if I might assist, the statement Senator Brown just made is true no matter the length of the tenure. At any point, if their decisions are not comfortable for whoever is the person he's speaking to, they can be reappointed. So I'm not clear on the concern on this one.
Okay, so I put 18.
Well, my concern is the fact that the minister cannot, except for 22, separate them. But after 3 years, they can easily be separated. I believe the tenure should be 5. And I so move. You can vote it down, but I propose an amendment.
Okay, there is an amendment from Senator Brown to increase the...
Not exceeding 5 years.
Yes, to increase the tenure of the members of the tribunal to 5 years, so that it would read, for the members of the tribunal shall be subject to provisions of this part, hold office for a period not exceeding 5 years, and shall be eligible for reappointment. That is Senator Brown's amendment, proposed amendment. Those in favor? Against? I am against? Okay, I think that the noes have it. So I put clause 18. Those in favor? Against? I put clause 19. Those in favor?
19, Chairman. There is currently a constitutional challenge to tribunals being appointed by the minister. And I'm wondering if the advice of the Attorney General's chamber have been taken on this, so that we don't get into an embarrassing situation of passing unconstitutional position. Given that a challenge is out there now, it would be good to be assured that it is the view of the Attorney General's chamber that it is not unconstitutional for ministers to be making appointment to tribunal, especially since you might find very well that a complaint goes to the tribunal about official in a ministry involving sexual harassment. as we have seen in some government departments, such complaints. And so I'd need an assurance that the Attorney General Chambers have the view that it's not unconstitutional.
Well, there is a presumption as such, you know. So I put clause 19. Those in favor?
It's a presumption as such, what? That it's constitutional. We did that presumption and needs to.
Okay. So I put clause 19. Those in favor? Against? I put clause 20. Those in favor? Against? I put clause 21. Those in favor? S 21? Okay.
Should be changed to is affected by a mental disorder. The leader didn't comment on it.
Thank you for reminding me. I did have it noted, but I did check with the technical team, and because the language under the Mental Health Act is suffering from a mental disorder, for justiciability and predictability, the advice is to keep the language as it is. But it was raised in the Joint Select Committee by Senator Longmore, and the commitment had been made to look back at the Mental Health Act as part of the modernization of legislation which makes these references. So it is to be done, but can't be done here if it hasn't been done in the Substantive Act. Yes, so please do. Thank you.
Thank you very much. So I put clause 21. Those in favor? Against? Ayes have it. I put clause 22. Those in favor? Against? Ayes have it. I put clause 23. Those in favor? Against? Ayes have it. I put clause 24. Those in favor? Against? Ayes have it. I put clause 25. Those in favor?
25, I have a comment. In the definition, it speaks to, I think it is on page 2. Hearing. Hearing means a hearing conducted by the tribunal pursuant to Part 6 in relation to a complaint. At 25, it says, paid for each hearing. And if hearing is relative to Part 6, when the committee, when the panel meets, when the tribunal meets to discuss issues of procedure, etc., that so certainly doesn't qualify as a hearing under this definition. Will they be paid? And again, I'd raise the question of the policy uncertainty. How are we going to be paying these people? If we're going to be passing this bill and we don't know if we're going to pay them, say, the way we pay the Industrial Dispute Tribunal, or we're going to be paying them some. It's bad law to be passing some with such uncertainty when clearly, as you have said, this has been a bill long in coming. We ought to know how we're going to treat them.
Thank you very much. I put clause 20.
Can I
I am proposing, sorry.
If the tribunal is going to have to set up their own rules and process and procedure, it means that they will be sitting, but they won't be hearing. And from my own experience of having to do that, it can take a considerable length of time. So I do suggest that you perhaps put, instead of hearing, sitting, so that it covers that sort of procedure that they will have to embark on.
Can we just get some technical advice on that and then come back to it?
Okay, thank you very much.
I don't have a difficulty if it is
so
that
we'll come
there
back
is
to
an
25. Senator Gale, you're going to get some clarification there for the minister in the meantime.
Thank you. And I just want to note that it's not a function of policy uncertainty. For the record, to note that it's not a matter of policy uncertainty, that this language is generally quite appropriate and regularly used in legislation. The details are not usually set out here.
I understand.
But on the matter of the distinction between hearing and sitting, I will await some guidance on
Minister, that is pellucid. 26. Those in favor? Against?
Just to be clear, is there any specific form for the keeping of the record of proceedings? And are the resources available for doing this? Because otherwise, we're going to be passing something that we can't implement.
No, but the bill provides for the procedures and the forms, the usual forms and procedures to regulate, for the tribunal to operate, and for the provision of regulations under this bill. So those will be done. There's nothing unusual about that.
No, it's not the unusual nature of it, because I agree that the usual nature ought to be. But is the resources available, say in the first 18 months when you're going to review this, for these things? Do we have the stenowriters to do it?
That's not an issue for right here, no, I would suggest.
Why isn't it?
Because I don't expect that you would expect to see about stenotypists in the bill.
No, it says there may be other ways of doing the proceeding, and that's why I'm asking whether or not, and we're being told it's the usual way. Are we going to be doing just audio as a way to record, or new ways of recording? But I'm told the usual way.
That is not for us to determine
right, thank
here.
you.
It's
I'm
for
going
the
to
most
put clause
modern,
26.
appropriate, efficient way to be determined. And
I'm putting clause 26. Those
like
in favor? I'm putting clause 26. Those in favor?
Aye.
Against? Ayes have it. I put clause 27. Those in favor? The ayes have it. There is an amendment on sheet 1 to clause 28.
There's in fact an amendment to sheet 1 on sheet 2.
Yes. So there's an amendment on sheet 1 and sheet 2. So I put the amendment on sheet 1 first.
No.
Yeah.
Sheet 2 supersedes sheet 1.
Okay. Sheet 2. I beg your pardon, Senator Sinclair.
He was quite clear on that.
Senator Brown, I think that you refer to what's going on between us in the trade union as creeping ambition. I think it's something that you are aware of. Not at all.
The amendment on sheet 2, Mr. President.
There's an amendment on schedule on sheet 2, which I put.
Yes.
Those in favor?
Aye.
Against? I put clause 28.
Before I put 28, I'm taking it that the current 28, and no, not recommittal, it hasn't been put yet. Clause 28, and page 21, where it speaks to no disclosure before the tribunal has commenced a hearing. I raise the question whether the respondent, at what point is the respondent to be told of a report or a complaint against him at the tribunal? Is it after the hearing has begun? Because it strikes me that makes no sense. So where is the provision for the informing by the tribunal of the respondent?
I'm not sure what the question is, but 28 is deleted and amended by a full duty of confidentiality, as I had indicated earlier, and it is set out on sheet 2. And it's a usual duty of confidentiality that subsists after termination. That is the amendment that has been put here, because there was uncertainty in respect of the language regarding the tribunal
so
and the timing.
So the 28 in the bill is deleted, is what you're saying?
It is in its entirety.
Okay, so I now put 28. Those in favor? Against? Ayes have it. There's an amendment to 29.
It has amended. 28
Pardon?
has amended. 28 has amended.
As amended, yes.
Yes.
I put the amendment.
You're saying here that the authorized officer shall conduct the investigation? Is that what it's saying here? And report to who? No, 29.
To 29 now. You had moved to 29, Mr. President?
Yes, I'm putting 29.
Okay, so the amendment is, yes, there is an authorized officer designated under 12 to conduct investigations, to take the matter from under the aegis of the tribunal.
And what become of this report of the authorized officer?
This is what goes to the tribunal for them to have their hearing, because the tribunal itself can't conduct the investigation. Separation of powers.
So the tribunal asks the authorized officer to, Scott Martin makes a report against me.
No, the minister appoints the authorized officer. The tribunal requests that an investigation be done, and the authorized officer conducts the investigation and provides the report, which is provided to the tribunal for its operation.
So when the tribunal hears the matter between Scott Motley and Brown, it takes into account a report
Investigations of the officer.
for which neither Scott Motley nor Brown may be able to cross-examine and question this authorized
No, but
officer.
of
No,
course,
no.
all of that information would be provided, but the rules of the hearing would not be set out in here, you know. Remember, the rules of the hearing, all of the procedures are going to have to be set out in regulations. That's not here. That's never put in the laws.
Okay, thank you very much. I think Senator Brown...
I
knows
have
that.
some deep concerns about this because I really believe it. This is where the separation of power and fairness comes in, and it doesn't appear to be fair to me. So I want to put on record my disagreement, strong disagreement.
Senator Brown, here you put it on record. Just vote against it. So I put clause 29.
I put on record,
Mr. Chairman,
Okay, go ahead, please.
a moment, please, because previously you had put the amendment to clause 28, which we voted on, and then you would have put amended clause 28, which we had not yet voted on when Senator Brown...
Yes, man, we did.
We did?
You want to do it again? I put clause 28 as amended. Those in favor?
Aye.
Good, yeah, I did. Who is so in dissent down there?
Not dissent, Mr. Chair. I just want to make sure we cover all our clauses.
So I put the amendment to clause 29. Those in favor? Against? I put clause 29 as amended. Those in favor? Against? Ayes have it. There is a minor amendment to clause 30 on sheet 1. Those in favor of that amendment?
So, Chairman, on 30? 30. Right. But I just want to, it's not seeking really an amendment, just a clarification that I asked for. Where there's a frivolous or vexatious complaint that is made, Clause 30 as is drafted says that the tribunal shall in writing inform the complainant and any person against whom the complaint was made, etc., of its reasons and findings, and the tribunal shall take no further action in relation to the complaint. Now, suppose a complaint was made, the respondent incurred costs through having to get counsel or otherwise of a frivolous, what is found out to be a frivolous or vexatious complaint. Is the respondent entitled to recover any costs? And my query comes up in light of clause 36C, where it says, 36C says, that the tribunal, after conducting a hearing, may make such award as may be appropriate in relation to the complaint. That's deleted? Okay, so if 36C is deleted, 36C is deleted. Okay, if 36(1)C is deleted, then, Mr. Chairman, the person against whom a frivolous or vexatious complaint is made and it is so found that it is frivolous or vexatious, but incurs a significant cost, where does that person get some type of redress for the cost from a QC, Mr. Chairman, that he would have incurred in engaging a QC to represent him at the tribunal?
Senator Sinclair,
yes.
Would 36(1)(b)(4) be able to cover that?
The respondent should pay to the complainant damages by way of compensation. So that is the respondent paying.
Yes, yes.
So,
you're right.
So
you're
in
right.
that, if I were even
it
to
doesn't
attach
cover it.
Right. So if I were even to attach that, then you see that everything is heavily weighted against the person who is the respondent, as against the respondent against whom a frivolous claim was made.
I see
And
your
so
point.
I need to get some
I see your
clarification.
point. There's no provision
on that
for
issue.
compensation.
Good intervention, sir.
Just to clarify, President, it's my friend Senator Sinclair saying that this tribunal should be able to award costs, as the courts do now, because my sense is, why should anybody go and make a complaint when the likelihood could be if you lose? Because that's the extension of it too. That cost could be awarded against you.
It is not just losing. It's not a matter of just losing, Senator Brown. Because if you bring an action, a complaint, and it is heard and on its merits, you may find that the complaint may not be, it doesn't reach its standard, because I believe
Sorry, Senator Sinclair, what you are suggesting is perhaps that is something that needs to be looked at in the review.
Well, I think yes. I'm just putting it on the record. If there is no amendment that can be done now, but I understand that there is a fairly early review. It's something that we need to look at.
Thank you very much.
I agree with you to put in the review, and I thank you for putting on the record, because guess what? It's the person's feelings that led to the complaint.
Yes, thank you
and
very much.
And then we're going to charge them for having bad feelings.
Yes, thank you very much. So,
Chairman, I don't want Senator Brown to get around it, because you keep going down that road. And I say, if you look at how the section is drafted, that describes it, defines it, it is not just a person's feelings. It is more than that. And to establish the unwelcome, look at it. There are several words that indicate the level that you'll have to reach to.
Thank you very much. Feelings.
Very interesting, Senator Sinclair and Brown. And all that. There's an amendment to 30, which I put. Those in favor of the amendment on sheet 1. Against? I put 30 as amended. There is no amendment to 31 that I can see, so I put 31. Those in favor?
No, 31, whether the notice at 31(2), tribunal shall not conduct a hearing or shall discontinue a hearing if the tribunal receives notice that the complainant does not wish the hearing to be held or to be continued. And I was inserting, since throughout the document we have in writing, notice in writing.
All of the notices are not in writing, and I had asked that the team just take a look through again in respect of which ones were in writing and which ones not, which ones left at large. The point being, so if the tribunal is told that the complainant doesn't wish to go forward, then it is acceptable. That is the position. That's why.
By the lawyer for the respondent, for example?
No, but anyway, I put clause 31. Those in favor?
Because Chairman, the question of who serves that notice is important, and whether the notice is in writing. We know the society operates, you know. We know it operates.
Thank you very much. So I put clause 31. Those in favor? Against? Ayes have it. I put clause 32. Those in favor?
Yes, sir. At 32, the tribunal may take evidence or oath, evidence and oath, or affirm, right? Person may take an oath or affirm. Why are we saying may? Why is it not shall? When a failure.
No.
Sorry, let me finish.
Because may mean one or the other.
No.
Language.
So why does it have
I agree
R?
with you, Mr. Chairman.
Why does it have R? You see,
Because
the
it's
question
either
is,
or.
The tribunal may take evidence
one or the other.
on oath
or
or
may
affirmation.
take it on affirmation.
The May, Senator Brown, is not relating to the evidence in it, is relating to the oath or affirmation.
that's the purpose.
So I agree with you, Mr. Chairman.
So I put clause, I beg your pardon? I put clause 32, those in favor? Against? Clause 33, no amendment that I can see, those in favor? Against? I put clause 34, no amendment that I can see, those in favor? Against? Clause 35, there is an amendment on sheet 1, which I put. That is to say, I put the amendment on sheet 1 to clause 35. Those in favor? Against? Ayes have it. Leader, I don't want to forget. Remember that we had left out something around. You got the instruction in it yet?
So clause 25 on the matter of...
Yeah, I prefer to just deal with it while I remember.
All right.
So we
We're going to
recommit.
jump around a little bit, though.
I'm going to,
We'll jump around a little bit. So
I'm going to just recommit it. That's 25.
clause 25.
If
yes.
you're ready to deal with it.
Yes, Mr. President.
And then I'll resume at 35. So the question is that 25 be recommitted. Those in favor?
Aye.
Against? Leader.
Yes, Mr. President. We are going to agree to an amendment here to insert the words "or sitting" after the word "hearing."
Thank you very much. Members would have heard the amendment which would read, in respect of each hearing or sitting. Those in favor of that amendment? Those in... Okay, so those in favor of 25 as amended? Against? For? Thank you. So thank you, Leader. Let me return to 35. There is an amendment on sheet 1, which I put. Those in favor? Against? I put clause 35 as amended. There are two amendments to clause 36, one contained on sheet 1, one contained on sheet 2. Both of them are to be put?
It's actually 4 amendments, but they start on sheet 1 and continue on sheet 2. So that the very last one, the 4th one, is set out on sheet 2. So it's,
Oh, yes, I understand.
Yes. Thank you, Mr. President.
Before, Mr. Chief, I just trying to appreciate in relation to 36, where in the amendment, it is known that you have a restriction on the financial amount that can be awarded. Previously, we had 36.3, where there was really no limit, but an award that could be made and could be recovered in a parish court, regardless of the amount, as a civil debt. And I just wondered why you have that limitation when you may find a situation that may be so egregious that 900,000 may not be satisfactory.
Yes,
And
I did raise that question myself. There are a number of issues that were considered. The uncapped limit was felt to be a matter which would be more appropriately placed before a court than a tribunal. It is a matter which is of some concern generally, and therefore it has been treated with. It was one of the elements considered in the transition from when it was to have been a court that had considered these matters rather than a tribunal. And the sense is that those cases that are so egregious that would go beyond the parish court jurisdictional limit, that is the $1 million, that limit, that there are likely to be the types of cases that would have a criminal element to it, for which civil recompense could also be sought,
or they would have a labor element to it that for which recompense could be sought otherwise as well. The point being that the usual case of sexual harassment would be one that could be addressed within this remit.
Thank you very much.
Just to clarify.
Hold on a second, Senator Brown. Just give me 1 second.
Go ahead, go ahead.
My second issue that I need clarification on is why does not make the award by the tribunal enforceable within this legislation instead of having to go to another, to the parish?
Right, that's actually there. But it's actually there in 37, it's binding. But it was felt that to ensure that there was a method of enforcement. So 37 says it's binding, but it was felt that to make it quite clear, this provision, which is found in other legislation as well, to say that it's summarily claimable in the event, because it is a tribunal at the end of the day.
Just to be clear, at 36(1)(b)(3), it allows for reinstatement. And I assume that reinstatement would carry a loss of benefit. Somebody earning $4 million.
I think you're not looking at the amendment, Senator Brown. The amendment deleted that because the issue was raised that reinstatement was a power of a labor tribunal, and that the persons on this tribunal are not necessarily trained in labor matters, and that it would that for this tribunal to be able to award reinstatement would go beyond its remit and be subject to challenge. So that was deleted. It's not in the amendment.
Thank you. So I can put the amendment to clause 6, which is on sheet. Yes, to clause 36, which begins on sheet 1. Those in favor? It continues on sheet 2, and I put the amendment on sheet 2. Those, pardon? Yes. Those are on sheet 2. And I know, those in favor? Against? So I now put clause 36 as amended. Those in favor? Against? Ayes have it.
And I just want to make clear for the record that in 36, where it notes the new item 4, the 4th amendment, that deletion of the words following after the words court are in subclause 3. That's actually not carried forward in the sheet. Yeah? No, it doesn't say that this is in clause 3, subclause 3. Just a typo. It's the 4th amendment, but it is actually in subclause 3, delete the following words. Okay? So just for clarity, for the record.
Thank you very much. I put clause 37. Those in favor? Against? I put clause 38. Those in favor?
What is the policy preference for appeal versus judicial review as a way to overlook the work of the tribunal?
Pardon me, Mr. President. Sorry, there was an amendment.
38. No, Senator Brown was asking a question.
I did. First, you want to make an amendment, but I'm just first trying to get the policy reason for taking the approach of an appeal versus judicial review.
I will take some technical advice on that.
Thank you very much.
Let's move
I'll
on.
get back
Thank
to
you.
38. 39. Those in favor? Against? Ayes have it. 40. Those in favor? Against? Ayes have it. There's an amendment on sheet 2 to 41, which I put. Those in favor? Against? I put 41 as amended. Those in favor? Against? Ayes have it. I put clause 42. Those in favor? Against? Ayes have it. I put clause 43. Those in favor? Against? Ayes have it. I put 44. Those in favor?
Mr. Chairman, I don't have a amendment formulated, but if I could just
You don't have an amendment
I'm
formulated.
trying, it's a little difficult for me to formulate it, so maybe I just make the point and then I'll see. The review time of the act being what it is, and this really is, I guess, a policy issue. Can we also consider the collection or collation of data at the point when the act comes into force, so that that review can take into consideration what data is collected? There are registers that are required to be kept, etc. And I'm not talking data in relation to names, but perhaps case numbers and so on for the consideration of the...
I think that to circumscribe the context within which the review will take place would be problematic, because then you're not going to capture everything that you need to review. There is a commitment to provide data. How it is operating will certainly be part of that. I have to say that the intention is to ensure that all the circumstances of the operation of the Act will be considered at its review. And I think to try to enumerate what those should be might be problematic.
Thank you. So I put clause 44. Those in...
Propose for 44 that the review take place, because it requires 18 months. But if you put not later than 3 years, you can do it at 18 months if you don't want to know. If the circumstances so low, if you put not later than. But
Thank you.
18 months really is just setting yourself up for failure.
Thank you. I put clause 44. Those in favor?
My amendment is not going to be put, sir?
You want to...
Yes, because...
No issue. And the amendment is what?
That not later than 36 months.
You should have heard the amendment proposed by Senator Brown. Those in favor? Against? Okay, thank you. So I put clause 44. Those in favor? I put clause 44. Come, guys, let's go. Those in favor? Thank you. I put clause 45. Those in favor? Against? And perhaps the most controversial of all, I put clause 46. Those in favor? Against? We need to return to 38, Minister. That's what we return. No, we dealt with it. 25, we dealt with it. The only thing outstanding is 38.
Okay, so I advised that the policy preference was to put the right of appeal over judicial review. If no provision had been inserted, then the default would have been judicial review. But the policy preference was for a right of appeal to be included.
Thank you very much. So I put clause 38. Those in favor? Against? I put the first schedule. Those in favor? Against? I put the second schedule. Those in favor? Against? I put the title and enacting clause. Those in favor? Against? The question is that I do report the bill as having passed committee stage with 25 amendments. Those in favor? Those against? I do report the bill as having passed committee stage with 25 amendments. Minister?
Mr. President, might I ask for third reading of the bill?
Thank you, Minister. The question is that the bill entitled the Sexual Harassment Protection and Prevention Act 2021 be read now for a third time. Those in favor? Against? Okay, I am sorry, excuse me. Members, you need to just pay attention 1 minute. There's a correction, which is as a result of a mathematical miscalculation. There are 23 amendments, not 25. So please note that for the record. The question is that the bill be read for a third time. Those in favor? Aye. Madam Clerk.
A bill entitled An Act to Make Provision for the Prevention of Sexual Harassment and for Connected Matters read a third time and passed.
Just before the motion for the adjournment, Minister, 2 of our members had sought and received permission to make interventions on the motion for the adjournment. Senator Longmore with respect to Breast Cancer Month, and Senator Fraser Binns with an environmental matter concerning reforestation. Both members have agreed to deal with those matters at the next meeting. So I thank you both. Minister?
Yes, Mr. President, allow me to again thank everyone who contributed to this bill, not only in this debate today, but just to add my words of appreciation to the technical team that has been working at this for many years, dealing with an area of such sensitivity and such controversies actually at times is not an easy thing. When you're trying to get it right. And I want to really just thank them for their dedication to the process. There's no way we could make laws for the good governance and peace of Jamaica without their keen minds and strong commitment to service. So with that, Mr. President, I want to wish everyone good health until our next sitting of the Senate, and ask if the Senate could be adjourned for a date to be fixed.
Thank you, Minister. The question is that the Senate be adjourned for a date to be fixed. Those in favor? Aye. Against? This Honorable Senate now stands adjourned for a date to be fixed.
Booking your COVID-19 vaccination appointment is simple. Use one of 2 options. Option 1. Register using the online portal at the Ministry of Health and Wellness's website. Go to www.moh.gov.jm, click Apply here for COVID-19.